So let's get started. So yeah, welcome to session one, so the evidence-based governance. I'm a moderator, so my name is Daisuke Fukamizu from Iranti. And yeah, and again, thank you very much for coming. So at the beginning, so may I ask you each to provide a self-introduction briefly. So Dan, I like your kimono, but yeah.
Thank you. I always do right by taking Daisuke's guidance on the kimono and everything else in the law and compliance. So first of all, thank you so much. It's so great to be here, and it's so great to be with you all. And thank you to Daisuke for putting this all together and having us together. And very honored to be on a panel with such great co-panelists who will make me look not as great when they introduce themselves, but let me introduce myself. My name is Dan Kahn. I am a partner at Davis Polk in our DC office. I do white collar investigations and compliance work. I started my career at Davis Polk and then spent about 11 years at the Department of Justice in the US, where I was the head of DOJ's FCPA unit for a number of years, and then I headed up the fraud section, which oversees the FCPA unit as well as the financial fraud unit and the healthcare fraud unit, and then ultimately became the acting Deputy Assistant Attorney General before returning to Davis Polk in October of 2021. And since returning to Davis Polk, I represent a number of companies in government investigations of all types, as well as internal investigations, and I advise on compliance work as well, and it's great to be here. Thank you.
There we go. Hi. Good to see everybody, and I know we've got many colleagues online, which is wonderful. I'm Lisa Osofsky, and when Dan was in his height of government work, I had the pleasure of working with him to bring home one of the resolutions. I was quite proud of the Airbus Deferred Prosecution Agreement. How was I part of that? At the time, I was the director of the Serious Fraud Office in London, England. If I don't sound like the kind of person who would lead the Serious Fraud Office, it's because even after 25 years, I never lost or gained a fabulous accent, which I know you will really welcome Simon's mellifluous tones compared to mine, certainly. I started life as an AUSA prosecuting corruption in Chicago, which was quite an easy one to do. There was an awful lot of corruption in there from Mayor Daley on up or on down, however you want to think about it. I worked in government, was seconded to the Serious Fraud Office as a very junior person to work on a big bank failure there, the BCCI bank collapse, and got my taste of what life would be like in London. Ended up back at the FBI helping under Louis Freeh lead the legal department there, and then went back to London with family and started the fabulous experience of becoming a British barrister. So I've still got my wig and my robe in the closet. It gets used for, mostly kids got very high marks for all of their holiday dress kind of competitions. And I helped then with Goldman Sachs. I was involved, having become a barrister, I was solicited by Goldman to take over a compliance function there, the first money laundering reporting officer when the Proceeds of Crime Act came into place. That was many moons ago. Fast forward, helped start a company called Exeger, where we focused on corporate compliance and risk and governance. And one of the keynote assignments we had was serving as corporate compliance monitor of HSBC Bank. And I had other monitorship roles before I joined the Serious Fraud Office as director. I'm now a partner managing director at Alex Partners. I do work supporting all my favorite lawyer friends, Dan and Simon included. I run investigations. I have some monitorship work that is still survived, even the most recent trends we're hearing about from the Justice Department. And I help clients set up compliance programs that are fit for purpose. So thanks for your attention in advance. I'll turn over to Simon.
Well, good morning, ladies and gentlemen, and to everybody online. My name is Simon Airy. I'm from global law firm McDermott, Will and Emery, and in London I lead the investigations and compliance team there. We are deeply honoured to be part of the Agile Governance Conference today. Daisuke, thank you once again for your invitation. We are very excited to be in this beautiful city of Tokyo. Daisuke has promised me that he has personally arranged for the blossom to bloom this weekend, so we are very pleased to be here. Today we have an exciting agenda, and perhaps we'll proceed to it straight away. Daisuke.
Thank you. So yeah, let me do a kind of stage setting. So first, and the society and market is now very complex, and so getting more and more complex. So and the information gap. So, and the information asymmetry between the government and the businesses are huge. So, and for the government, it's not realistic to investigate the corporate crime by their own without the cooperation of companies or businesses. So, and the government should think about how to encourage companies to proactively govern their companies in an efficient and effective way. And the question is how to do that. And I think the US and the UK started to think about structuring the very good incentive structure to encourage companies to do that. So, and having said that, so the one question, so, and one challenge we need to discuss is, so when we think that incentive structure work, so the company should understand so which is a good compliance program, and also for the government, they need to evaluate fairly and effectively so whether the compliance program is effective or not. So and so that's why so effectiveness is very, very important so far, and in order to establish the effectiveness, I think companies should think about how to prepare for the good evidence to demonstrate that the compliance program is effective. And also for the government, in order to give a benefit or credit to the company, so they also have a good understanding and knowledge and the capacity to evaluate the compliance program with evidence. So, and that is why we chose this topic first. So it's a really good starting point to discuss the governance issue at this point. And let's move on to the first issue. So, and we will discuss the US situation first and then go to UK. And Dan, also may I ask you to briefly explain the US situation from that perspective?
Yes, absolutely. And you're exactly right in terms of the importance of the compliance program. It's something that has become increasingly important to regulators, not just in the US, but as you'll hear from Lisa and Simon, in the UK and many other jurisdictions. In the US, back in 2017, DOJ put out a guidance document, the evaluation of corporate compliance programs. That then has gotten enhanced and revised several times over the years in 2020 and 2021 and 2023 and 2024. And the purpose of this document is really to provide both prosecutors a guide for how they should be thinking about compliance programs, the types of questions that they should be asking companies when companies are presenting to them about the compliance programs. And I think from my perspective, even more importantly, it is a transparent way to share with companies, number one, the way that DOJ will be thinking about compliance programs, but number two, I think it's probably the most detailed guidance document in terms of compliance that companies can look to help benchmark and to help see if they are truly thinking about compliance in the right way. And the purpose of the evaluation of corporate compliance programs, what it really is getting at, even though it's I think 18 or 20 pages long. The thrust of it is, how are companies thinking about compliance? DOJ wants to understand how companies are thinking about analyzing and processing risk and how to address it. And then they want to see the evidence that the company is in fact testing and ensuring that the compliance program is effective. And so to just hit on some of the more recent amendments, and this is really now over the course of the last 2 years. One relates to messaging applications, the use of personal phones, personal devices, WhatsApp, Signal, those types of communication platforms. Frankly, from my perspective, I don't think that there is a good solution for that. I have advised a number of companies on how to address it, and I think there's really only so much that a company can do, but there are steps to evaluate the types of communication platforms that are being used by your employees, and then addressing it through the use of policies, training, some degree of monitoring and discipline. The second is compensation structures and ensuring that the types of compensation structures that a company is putting in place is encouraging and incentivizing compliance. Again, I think that's a very tricky issue. It's easier to take away compensation or to withhold or penalize someone if they engage in some non-compliance, whether it's termination or some sort of reduction in their salary in coming years. In some jurisdictions, not this one, but some jurisdictions, it's easier than others to claw back compensation. But that is another topic that has been added more recently to the evaluation of corporate compliance programs. And then the third, and you're going to hear from a great panel next that are really the experts on artificial intelligence, but the evaluation of corporate compliance programs was amended back in September of last year to essentially say that if companies are using artificial intelligence as part of their business, that the company should be evaluating the risks associated with the artificial intelligence and making sure that they are taking steps to train employees about those risks, to implement controls to mitigate those risks. And if companies are using artificial intelligence as part of their business, they should be asking whether they are also using it as part of the compliance program, and if not, why not? And then finally, the last point is anti-retaliation, whistleblowing, and making sure that companies are aware of these issues and training employees about them. I know I've been talking for a very long time, so I'll hit the last bullet very, very quickly, and I apologize about that. But in terms of what to expect in this administration, I think as with many things, we're still waiting to see how the administration, the current administration, is going to use a lot of the policies that have been put in place over the last 8 to 10 years. That said, I think this is going to be a continued, very important document in future administrations, even if it's not in this one, but also perhaps more importantly, as you'll hear from Lisa and Simon, it's important for foreign authorities which have been using it, and it's important for counterparties, auditors, and things like that. But we'll talk more about that, and I'll now stop talking and turn it over back to Daisuke.
Yeah, thank you, Don. So, and may I ask Lisa, so since you have experience in not only US, but also UK, so could you explain the contrast? So as Dan said, the ECCP is a kind of detailed guidance, but what is the situation in UK and how is it different? So could you explain a little bit?
Sure, and we were always grateful to get the guidance from the DOJ. We were very happy to use it to see what our American counterparts were doing, and we also knew we had a different system. So while we've heard that there may be some pullback in the US, that's certainly not the case in the UK. Indeed, we'll have a chance to chat through a little bit more how we are looking at a new change in the law in the United Kingdom, good as of the 1st of September of this year, that's going to make and broaden the fraud offense that we've got to include failure to prevent, currently existing in the bribery space and also tax evasion overseas. And we have already seen, as of December 23rd of 2003, a widening of the kinds of behaviors that will bring corporate liability. So we can talk more about that later, but I think the backdrop is we learned a lot from our cousins across the seas. We saw a lot of detailed guidance that was very, very specific. So you'd see, if you come to us on day 3 and you provide the following 4 documents, you too can expect a 10% decrease in what you might find at the end of the day. I'm overstating it a little, but it's quite a granular approach to coming in and full transparency, really, on the part of the government. In the UK, we didn't have those documents. When I was the director of the SFO, I came out with some. I mean, my predecessor at the time thought, that's not for prosecutors. We're all about seeking penalties and putting people in jail. The explaining, that's for the consultants. But I thought actually the DOJ had it right in some ways. It was fair to tell companies what they might face, the kinds of things that we at the SFO were looking at and looking to evaluate them for if they came in to talk to us. I wasn't just doing it to be nice. We wanted companies to come in to talk to us because no matter how well-resourced a government agency may be, we certainly weren't that agency. We were not well-resourced, and it was always helpful to have the corporate come in to tell us a little bit about what had gone wrong and how they were going to fix things. So we have a much more general guidance out of the UK, and yet I think it is a step forward from what had been the case before, which was basically, we're the prosecutors, come talk to us, and we'll let you know whether it was good enough. And I think, as I say, I'm overstating it a little, but the areas that we look at are very high level, and it won't surprise you to hear they include top-level commitment, starting with a very detailed risk assessment. We can, I think, have a very fruitful conversation about what a risk assessment must entail, what it could entail, how to do it right as a corporate, and we'd love to hear any questions you have around risk assessment, because that is now an important part in the UK of the law that is coming into place September 1st. And we know that our corporates operating in the UK are very focused on this. It includes due diligence and communication, training, monitoring, reviewing to tweak to make sure you've got a program that is fit for purpose, not just on the day you put it into place, but in the year hence when you've learned a little bit more about what's working and what isn't, and you continue to make sure that that program is living and breathing. I think I'll stop there and allow Simon to focus with us a little bit more on, oh, sorry, Daisuke, I don't want to take your role away. Apologies, Daisuke.
Thank you. Yeah. And so as Lisa said, so there's a significant legal regime change in 2023. So driven by the ACTA. So and Simon, so it's your turn. So please explain what ACTA is and how that affect the compliance evaluation and also so the guidance was issued I think in November last year. So and please explain this to the development.
Thank you, and I think we have another slide for this one, don't we, Daisuke? Yes, ladies and gentlemen, I think it's fair to say that events in the United Kingdom are going to fundamentally change the way that corporate criminality is assessed and prosecuted. One of the reasons for that is that, unlike the United States, we do not have a developed sense of plea bargaining with prosecutors. Sanctions are essentially the preserve of courts, and in reality, the only way in which a prosecution can be avoided is if a company earns the right to a deferred prosecution agreement, which then needs to be approved by the court. Combined with the fact that it was almost impossible to prosecute companies in the United Kingdom, Lisa and her predecessors at the Serious Fraud Office were extremely frustrated. And after a well-known case involving a bank where the prosecution failed, the law was changed as a result of intense lobbying. And what we now have is probably the most important development in corporate criminal legislation for over 100 years. The changes now are so fundamental, they're going to bring us much, much closer to the United States. And at a time when the United States may be withdrawing from active prosecution overseas, there is a big question as to whether, in fact, the British, the French, and other sympathetic countries will step into the void. So we have ECTA. What has it done? First of all, it has expanded the concept of corporate criminal liability outside of the boardroom. Under the old law, it was only possible to prosecute a company, in essence, if you could demonstrate that board members were involved in the crime. If they were, their conduct was transferred, it was imputed to the company. Now we have the concept of a senior manager. It's a very broad definition. It's somebody who is involved in devising management of the company or actually involved in management of the company. If a senior manager is involved in criminality, their conduct can now be imputed to the organization. It's a very broad definition. It probably means there are dozens or even hundreds of people in big companies who may now implicate the company in criminality as a result of their role. That is a huge development in the United Kingdom, but it is supplemented by a second change, which I'll tell you about in a moment. In terms of the senior manager regime, it's important to note that's already in force. Those changes were implemented on the 26th of December of 2023. So 15 months ago, the law changed. Many people haven't realized this, but risk exists today. As regards future changes, on the 1st of September of this year, the law will be further expanded and a new corporate criminal offence will be introduced of failing to prevent fraud. If a company fails to prevent fraud anywhere in the world by anybody associated with the company is automatically liable. The definition of an associated person who commits fraud is very broad. Essentially, all employees anywhere in the world, if they commit fraud, then the company is automatically liable, unless the company can show that it had implemented reasonable procedures that were designed to prevent fraud. In other words, a compliance program. That is a complete defense and applies to conduct in countries all around the world. It's important to remember that under the senior manager regime and under this new offence in September, there are extensive extraterritorial aspects of the law, which means that conduct and companies overseas are affected by this new legislation. The reason this is so seismic, so important, is it for the first time gives the Serious Fraud Office and other prosecuting agencies in the United Kingdom the ability to prosecute conduct for the first time ever. And because the definition of fraud is so broad, it will cover conduct that happens in organizations every single day. So this is a complete gift to Lisa's successor, who is very excited about this. He has powers that Lisa did not have. And we know that the Serious Fraud Office is extremely excited about their new powers. Certainly, the new law coming in September. But I suspect they're going to be even more excited about the senior manager regime, where a senior manager commits crime. And the reason for that is that there is no defense of reasonable procedures. That defense only applies to the second aspect coming into force on the 1st of September. So if a senior manager commits crime, you almost certainly have no defense, unless, of course, they didn't commit the crime. These two aspects mean that prosecutors in the United Kingdom are very excited. So, a warning in some respects that we have a lot to do, because if we are to take advantage of the defence in relation to the failure to prevent offence, there is much to do before the 1st of September.
Great, thank you, Simon. And yeah, so let me ask one question. So I think, so yeah, since you said, so the type B fraud, so failure to prevent fraud, so there's a defense. So if the company so establish, so they have and operate the reasonable fraud prevent procedure, so they can, yeah, so cannot be liable. So could you a little bit explain, so what's a reasonable fraud prevent procedure and what it looks like and what kind of, what the guidance is saying, so about that kind of procedure? Simon or Lisa?
Reasonable procedures will depend on your company. If you've got a couple people operating, well, although I was about to say this, but there's a carve-out for really small companies, as we know. But we know what's reasonable will differ depending on your sector, depending on the jurisdictions in which you operate, depending on how much your employees are face-to-face on the front lines all day, every day. But we know from the training, as I say, quite broad type strokes about the kinds of things that make for a reasonable program. And those will include, as I said before, and keynote, first and foremost, a risk assessment. You need to know exactly where the risks lie for your company when you're out there doing business. And that will require an awful lot of legwork, and it will require an awful lot of data, and it will require talking to your people to figure out where the problems might lie, looking back on where problems have happened before, and trying to determine how best to make sure they don't happen again. As I say, the guidance will look quite similar to those who are well-schooled in the UK Bribery Act type guidance. There's basically 6 broad topics. They include the risk assessment, due diligence, monitoring transactions, communicating the message, tone from the top, all of the messages that we've heard in the UK Bribery Act context are now brought in for you to use them and to determine how to fashion a program that will work in the fraud context. And it's going to be very important that you are able to document how you've made decisions about where you put your resources, because showing that you've got a reasonable program to a prosecutor or a regulator who doesn't really know your business and will try as best as they can, and I think we did try in our respective former roles to understand who was coming in and what their business model was like and how they made their decisions, but you know your business better than anyone from the outside is going to know it. And so building that effective program is going to very much be a matter of hard work, working with external counsel, oftentimes, because yes, you know what you need to do internally, but you want to make sure that you're collecting all of the information to develop this risk assessment in a way that won't come back to bite you. So I'll leave it there, but to say that what's reasonable is something I think we can all talk about, and I would welcome anyone from the audience that is in a specific sector where they're curious, they want to explore it further. We want to discuss with you these sorts of standards in a way that you can bring home and bring back to your company effectively.
Thank you. So Dan, so I can, may I ask one question to you? So is there any similar defense so in the US regime?
No. Um, so in the U.S., I'll give a little bit more context and color for that answer. There is not an outright defense for a compliance program. That said, the U.S. has an extraordinarily broad view of corporate criminal liability, and I think Lisa and Simon and Daisuke and I have had many conversations about the difference between corporate criminal liability in our respective jurisdictions. And the U.S., basically, if there is anyone within the company, even the lowest level employee, who is engaged in misconduct within the scope of their employment, which is viewed very broadly, and at least in part to benefit the company, it doesn't have to be wholly to benefit the company. The person can also be trying to benefit themselves. But if they are also doing something that could be viewed as trying to benefit the company as a whole, even if it's the lowest level employee in a company of 100,000 employees, then the company could be liable. And so why a compliance program is so important is DOJ and SEC and other regulators in the U.S. will look at whether or not the company has taken good faith efforts to implement an effective compliance program and to prevent the type of misconduct that employee or even many employees engaged in. And so even though there is not a defense in the same way that there is in the UK that can get you off automatically if you can prove it, a lot of times it has led to situations where the DOJ and SEC have chosen not to prosecute. And it also, in addition to those types of situations, even when there is going to be a resolution, the effectiveness of the compliance program can lead to a dramatically reduced fine or penalty. It can lead to a much more lenient resolution. Instead of having the company plead guilty, the company can enter into an alternative type of a resolution, an out-of-court agreement that the government won't prosecute the company, and the company can avoid having to retain an independent compliance monitor. Lisa was one of the good ones, but a lot of times monitors can be incredibly expensive, burdensome, intrusive on the company, and so that is something that every company tries to avoid, and having an effective compliance program can help you avoid that.
Thank you. So another question to Lisa and Simon. So under your regime, so if the company again demonstrate that they operate the reasonable fraud prevention process or so at their company, so who can decide whether or not their compliance program or their procedure is reasonable? And if you expect judges will decide. So my question is, are they able to decide whether it is reasonable or not?
No judge has opined on this yet in our jurisdiction. So it hasn't been tested. And that's because, in effect, it's the prosecutor that is deciding and making that decision in the first instance. Yes, as Simon says, the judge will have to sign off on an agreement. There is no such thing as an NPA, a non-prosecution agreement in the UK. You don't just have prosecutors resolving matters outside of the auspices of the court. So you will have a judge who will ultimately potentially look at what's been offered up as a reasonable program, but it won't get to the judge unless the prosecutor thinks it ought to do so. And so that's, in a way, that's who decides on the outside. On the inside, I think many of the people in this audience will have to decide what makes for reasonable procedures. It will be up to you as the compliance officer, the general counsel, somebody else in a position of authority within your company to decide what makes for a good program. And you'll want to take advice from external counsel like Dan or Simon along the way, and you'll want to make sure that you, in your role as a leader or compliance officer or counsel within your company, are exploring fully the kinds of processes you know you need to have in place within your company to make for a strong and robust compliance program.
Thank you, so, Simon.
It's very interesting to me that about 4 or 5 years ago, the Serious Fraud Office took the decision to publish and release a chapter for its internal handbook for investigators, SFO investigators. Why did they publish that? Well, I think what they were trying to demonstrate to the public is what a prosecutor would be looking for at the beginning of any investigation. And as regards bribery at that time, it was clear that prosecutors were going to be asking at the beginning of any investigation for evidence of a compliance program. Why? Because if the evidence was strong and robust, it would mean the company would have a defense. And at the beginning of an investigation, a decision could be taken on whether or not to proceed. If we interpret that more generally, what we understand, of course, is that if there was no obvious evidence of a good compliance program, there might not be a defense, and therefore it was a good case for the prosecutor to take forward. The handbook revealed that investigators would be looking for real evidence of a proper compliance program, not just a piece of paper, not just something sitting on a shelf, but a living, breathing, adaptive set of policies and procedures that had been properly implemented across a corporate group, were complied with, and were in accordance with the guidance that had been issued by the government about what a good compliance program looks like. 50 pages of guidance in relation to the Bribery Act, and now, of course, we have another 50 pages in relation to ECTA and failing to prevent fraud. We remember, of course, that this is just guidance. It's not prescriptive. It is for companies to decide, normally with the benefit of advice, what is likely to pass muster in the United Kingdom. As Lisa says, ultimately, if a case is deemed appropriate for a deferred prosecution agreement, then a judge will have to approve that. But it's right that the investigators are going to be the first port of call. They ultimately will decide what is good or what is not.
Thank you, Simon, for your clarification. And so let's move on to the next topic. And as you said, so the question is, what is living, breathing compliance program? So we now can agree that the compliance program is effective. Compliance program is very important. So, but I think the audience question is always how to achieve that. So, and as Lisa said, so the risk assessment is very, very important. So, and Simon, so may I ask you a question? So, how to conduct a detailed risk assessment to meet the external expectation?
This is probably the most difficult thing that any company will do if they're going to do it properly. It is the first step in 6 key guidance features in the formal guidance that have been published, a risk assessment. This is a deep process, often across a multinational group, that will require the company to understand all of its relevant risks, where it does business, how it does business, who it does business with, what its agents and intermediaries are doing, and where the real risks of the relevant criminality exist. We need to obtain evidence of real risk, not just theoretical risk, and that requires a deep dive. In many countries around the world, of course, there are cultural barriers to asking these questions as to where the risk of criminality lies. But the message is very clear in the guidance. It needs to be an effective risk assessment. So we do need to ask difficult questions. We then need to gather that information and understand how we design policies and procedures to meet those risks. The difficulty, of course, is if we are bringing all of this data and evidence in one place to constitute our risk assessment, we have to be very careful we do not create a written roadmap for prosecutors. And so the methodology of how we go about a risk assessment is very, very important. If we can do it under advisement and the protection of legal professional privilege, we can keep these processes confidential in many situations, but we need to understand at the outset of any risk assessment process how we're going to do it. So if I have one message for the audience here today and online, is take advice at least at the beginning of the process to understand what you need to do, in particular how you need to do it, and especially those things that you should avoid doing if you don't want to create that risk map. Lisa?
It's also going to be important, though, that you can ultimately show that you took steps, that you have tracked what you've done well. So the cautionary part is certainly there, and the part about making sure you document what you do and how you do it is also going to be relevant, because at the end of the day, no prosecutor is going to be looking at that unless something goes wrong. And if something goes wrong, one of the questions will be, where did it go wrong? How did you get it wrong? What were the questions you didn't ask? Why did you decide it was okay to have 10 compliance professionals rather than 20 sitting in this difficult area or this challenging part of the world? So you'll want to be able to document everything you've done, but as Simon says, with the knowledge that it can be looked over, you want to make sure you keep the right kind of records in the right way. You'll also want to be sure that you really understand your business. I mean, I know when I got to Goldman as a compliance officer, I had been an FBI lady. I had been a prosecutor. I didn't know the ins and outs of the trading platforms in which we dealt. And so it was my job when I got there to really, really understand the business, which meant asking a lot of very basic questions. And so my sort of message to you would be, don't be afraid to ask the questions you need to ask to figure out where the real risks lie. Just because you've got some terminology or acronyms that many of your colleagues seem to talk in and understand doesn't mean you need to accept that. Your job is to really get in and look under the bonnet, as we'd say in the UK, and really understand exactly how the business is run and where the issues lie. A couple of interesting features of programs that I had to evaluate as a prosecutor included one where, and this is on the training front, it was very interesting to note that all of the training was being given the world over in the language of French, in one particular language. Guess what? If you want a proper program, you've got to be training your employees in a language they speak. That also means you've got to be training them based on documents that are not the size of what used to be the Yellow Pages, for those of us who remember the Yellow Pages. But it's got to be a document that's simple, clear, and concise. You've got to be communicating your points in a way that your employees really can take them on board. Because the one thing a prosecutor looking at, some of these compliance programs that could get a gold star from the Compliance Institute, but they can't be implemented and embedded on the trading floor or on the sales floor or when you're selling medication in a particular that's just not going to be good enough. So you've got to make it simple. You've got to train on it. You keep track of all your training. And you've also, in doing this, need to think about your audience. So you think about the audience, your internal audience, the folks that you're working with and trying to get them to buy into the program. You think of your board that you've got to explain why you're doing what you're doing, and potentially an independent monitor who may come from outside and is kicking the tires and trying to figure out exactly why you did what you did. And There's another host of folks who might be interested, including class action litigators, those who engage in litigation funding, who may be coming in to see what sort of mess got made and how they can benefit from that mess.
Thank you, Dan. So, yeah.
Zut alors. Sorry, is that French? I think that's French. I don't know. Okay, sorry. I'm not good at that. But so everything that Simon and Lisa said were muy bien, but I think that's some language. That's the only thing I would add is just in terms of sort of to the broader question of how to do the risk assessment. And there's, as Lisa and Simon said, there's a range of options. Just a couple things that I would just throw out for consideration. Internal inputs and external inputs. So the internal inputs would be really trying to leverage any prior risk assessments that were done. You're looking at policies and procedures, internal audit reports, hotline reports that may flag certain types of risks and issues, to the extent there have been internal investigations and discipline. So you're really trying to look at any sort of written work product that you can pull to see and understand what the risks are, and then combine that, as Lisa was talking about, with some interviews. And it might be a very informal discussion with stakeholders, whether it's compliance and folks in compliance in various regions who understand the risks, legal, and very importantly, the business as well. So those are your internal inputs, and there's more that you could do, but that's, I would say, probably a detailed, basic version of it. And then the external inputs would be looking at the laws and regulations of the various jurisdictions you're operating in to make sure that you understand what the landscape is, as well as looking at prior enforcement actions that were brought against competitors of yours, companies that are operating, even if they're not competitors, if they're operating in the same region, to try to understand what types of risks are being faced in that region. Those are the types of external inputs that you can be looking at as well.
Thank you, Dan. So let me ask stupid two questions. So for you all, one is, so for the company's perspective, how often should we conduct the risk assessment? And second question is, what kind of evidence we need to prepare for? And do you have any idea from that two questions? Simon, please.
Well, obviously, if we are doing our risk assessment for the purposes of complying with the Bribery Act, or now ECTA, we need to be doing it now. The law will be coming in on the 1st of September, as we said. It may be, of course, that organisations have already undertaken some kind of risk assessment, as Dan said. So it may well be that we don't need to reinvent the wheel. We may be able to adapt or build on risk assessments that we have already undertaken. If we haven't conducted a risk assessment, then, as I said, it's quite a complicated process, often, for a multinational group. And taking advice is going to be important if you don't want to waste time or money. In terms of what you may do afterwards, it may simply be necessary to refresh a risk assessment. For example, if you enter into a new country, you buy a new business, you engage in a different type of activity. These may all change your risk profile. You may need to do a new risk assessment if you engage in a joint venture or go into a business with new parties that introduce new risk into your business. So I think it's fair to say that initially, for the main risk assessment, it needs to be done probably quite urgently and in depth, maybe a little less if we are upgrading or we are updating our risk assessment. But also I think it's quite important to anticipate what the future holds. And I think our next panel will also touch upon how technology and predictive data can protect us for the future. We all understand that there is not unlimited time, there is not unlimited money, and so in conducting a risk assessment, it's important to do so efficiently, concentrating on the real risks that affect your business, not the theoretical, as I said earlier.
If I could just add one feature to why you might want to refresh. If something goes wrong, you'll want to make sure to do a lessons learned and a debrief, digest that, feed that back in, and make whatever tweaks or changes you need now with the benefit of that knowledge. That will be extremely important. And then I'd say one area to think about in terms of a risk assessment that we hadn't yet really touched on as much is how your company deals with issues that come up. So what sorts of methods are chosen to deal with an issue that comes through the whistleblower hotline, for example? Are there obvious, clear escalation points so people know where to go if they see something? Are investigations conducted? And if they're conducted, are there resolutions made? Do those who were involved learn about the issue and how to deal with it next time? These are all the kinds of things you'll want to be thinking about in assessing risk and trying to put in place mitigations and methods forward to deal with risk effectively and in a robust way that will find favor with those who are going to second guess you. In other words, people like us who are sitting in a regulatory or prosecutorial seat.
Used to be us.
Used to be us, of course.
Not us anymore. We help you now. No, the last point that I would just make, because I agree with everything that's been said, is I think and Simon, tell me if you disagree with this, but I think Simon was very rightly pointing out that there is a targeted risk assessment that you can do that would not be company-wide. So if you enter a new market, you'd be doing a risk assessment with respect to that specific market, not company-wide. In terms of, Daisuke, your question about how frequently, there's no right or wrong. It depends on the company. It depends on how risky your business is. But I think a lot of companies refresh a company-wide risk assessment sometime between 3 to 5 years.
Thank you very much. And then go to the next topic. And in order to evaluate the effectiveness of compliance program, so we need to test it. And the important question is how we should test the effectiveness of compliance program, and it's part of the compliance program, like a training and the culture of compliance or speak up culture and the policies and procedures. And let me start from training. And so could you share your experience how to demonstrate and how to test the effectiveness of a training system in the company? So Dan, would you like this?
Sure. And so training is one that may not be the easiest to test because, a lot of times what companies had done in the past is just talk about the completion rate, which doesn't really tell you how effective the training is. It just tells you how effective the sort of communication mechanism is and whether the people are turning it on. It's not even telling you whether they're in fact even listening to it because they may just have it on in the background, which a lot of us have probably done with trainings over the course of our careers. So you could also then test after the training is done, but that doesn't really tell you how effective the training is. It just really tells you what the person knows. It might be that the person knew that even before the training, and so the training is not particularly effective. And so you could, take it a step further and train before the training and see what they know, and then compare it to what they know after the training. That's one way to do it. There's a very brilliant professor that we know, Eugene Soltis, who's spoken a lot about that particular issue and measuring effectiveness more broadly. But I think you could also look at, sort of the trends in reporting that take place after the training. You can look at the trends in violations of the compliance program that take place after the trainings. And you could also have focus groups, have discussions with people, take feedback, do questionnaires to try to gauge whether people are finding the trainings effective, whether they're finding it engaging. So again, I think training is one of the tougher ones to really measure, but that, and I'm sure the AI folks who are coming up next will have a lot more advanced ways of doing it, but I'll leave that to them.
I'd like to add that I think Dan's discussion focuses quite rightly on online training. I think mostly is sort of how I read into your answer. I'd like to add, I think some of the best training you can do is in person, because you need to leave time for people to ask questions. And they may not ask questions in a big group like this, but I can tell you, as I was going around Goldman Sachs, various pockets of our business, I would typically get the best questions with someone sort of tugging my arm on the way to the lunch area, before or after a training session. It's not always feasible to train in person, especially in the global and big companies that we are often representing. But boy, to the degree you can share and spare a little bit of time to, and it can be doesn't have to be the most formal training either. It could be you have a lunch and learn session when you happen to be in an office outside of your normal headquarters, and you just make it a point to have a bit of a discussion around some of these areas. I also think trends in reporting are interesting because it can cut both ways. You've got lots more reports. Are you doing a lot more wrong, or are you doing everything right? People finally want to step forward and talk about it. And I think it's worth thinking about some of the cultural differences in different jurisdictions where it might be seen to be very anti the company if you raise your hand and point out a problem. So we may have a job ahead of us in terms of trying to get real buy-in and people who are actually willing to tell us when there are problems and when there are things that could be better and when there are things that possibly need some readjustment of how we run our programs.
Simon, do you have any thoughts?
Yeah, look, what is an effective compliance program? An effective compliance program is one that is understood. It is one that is capable of being complied with. It is one that is understood in Beijing, in London, and in the United States. And so the design of a compliance program is important for it to be understood. The maximum bang you will get for your buck, I believe, is good training. Good training will tell you what the issue or the problem or the risks are. It will tell you how to spot them, and then fundamentally it will tell you what to do about that. Whether you report it up to line management, or you use a whistleblowing hotline, or some other issue. As Dan said, one way of testing the effectiveness of training is what happens afterwards. I did some training just a few months ago for a big company here in Japan. In the following week, 22 whistleblowing reports were made. The General Counsel was appalled and delighted because what it demonstrated is that there were problems, of course, but people were now identifying the problems, which meant the General Counsel could deal with the problems. So in short, I think a well-designed training program, probably not online in many instances, but tailored, delivered personally, and permitting questions to be asked, is where you will learn and convey a lot of learning with maximum impact.
Thank you, Simon. So I think you mentioned the whistleblowing report. I think we can focus on the whistleblowing structure's effectiveness. So, and Dan, so may I ask, so how to ensure the effectiveness of the whistleblowing structure within the company?
Yeah, I think, look, speaking to what Lisa and Simon said, certainly when I was at DOJ and in talking with companies, I think one of the most effective ways of telling whether or not your whistleblowing hotline and your whistleblowing structure and your speak up culture is working is not simply whether you are getting reports, but what type of reports you're getting, whether they are anonymous or not anonymous, and then what is happening with them, and where are they being reported to. And so certainly the hotline itself, it's great if that is working. It's great if you're getting reports, and if they're not anonymous, that is, I think, one indication that employees feel safe and comfortable reporting and not worrying about retaliation, having confidence that their concerns are going to be taken seriously. But from my perspective, one of the best ways of determining whether or not your compliance program is effective is, and the culture is effective, is if people are reporting not through the hotline, but to their business manager. And raising things directly to their business manager, and their business manager is helping to address it, reporting it to compliance. Those are examples that I would strongly recommend, to Lisa's earlier point about documentation. Make sure you document that and keep track of all of the reports that come in, not just through the hotline, because to me, both when I was at DOJ and now, that is one of the best examples of an effective compliance program.
Yeah, thank you so much. But so I think the companies may ask you, so it's easy to track or to prepare the data or preserve the data of internal whistleblowing report, but it's not easy to capture or report to their business. So boss or higher senior management. So it's not easy to capture or the number of these reports. How do you do that?
Yeah, so it's a great question, and it sort of depends on the complaint, right? If someone is complaining to their boss about a disagreement that they're having with one of their coworkers, that's obviously not the type of thing that I think is what we're talking about. It's the type of thing that would be escalated to compliance, and so or legal. And so if there is misconduct that's reported to a business leader, hopefully the business leader has been trained and understands that they should be reporting those types of issues to compliance, to legal, whatever the appropriate reporting function is within your company. That should then be documented and tracked. And so that is the type of thing which, if it's coming to you within your compliance or legal role, there should be some tracker to keep track of those complaints that are coming in or those issues that are coming in, both because it's good to show DOJ that people feel comfortable speaking up, but also because for your company and learning from prior mistakes, training and addressing issues that have come up, you certainly want to keep track of it. I mean, you never want to be in a situation where someone reports something, you address it, you deal with it, but you don't remember a year later, 3 years later, what the issue was, how it was addressed, because 3 years from now or 2 years from now, another issue may come up that in isolation by itself may not indicate a broader problem, but when you look at it in combination with the prior issue, you start to see a pattern of a type of issue that reveals a weakness in a control. And one of the things that also I think a very effective compliance program will do is make sure that there is some degree of parity in terms of discipline. And so you want to make sure that you're keeping track of the type of discipline that was imposed for various types of misconduct. And so you don't want to be in a situation where you didn't discipline someone for the exact same conduct that 2 years later you do discipline someone for, and they bring some sort of a employment complaint against you. So there's a number of business, legal, and compliance reasons to keep track of all those types of reports.
Thank you, Don. So one another question is that in the middle of this page, so we look at the phrase, so integrated, so the organizational structure. So when I have investigations in Japan, so we usually have observed very serious silo or structure within the company, and I think almost all traditional Japanese companies are struggling to ensure the organizational structure which is integrated. So could you give me some tips or experience to tackle that issue?
I think that is one of the critical, hard areas for not just Japanese corporates. Really, I think this is a global problem, or it can be a problem. Really good compliance programs ultimately result in the entirety of the workforce feeling like compliance is their job. It's not just the job of the person 3 corners down and 3 flights up, but it's actually something that we all have to take responsibility for. That's a very hard bar to meet, but it really does make for a properly functioning, robust program. And so when I think about integrating that, I think about messaging appropriately that everybody has to get on board with this, and trying to make sure that it doesn't just become the province of a particular specialty or a particular department. So how do we do that? I mean, that's hard. I think it takes training, retraining. It takes training in a way that makes for, we have very simple, straightforward rules. There are often, I mean, I'm just thinking back at Goldman, we had our 10 principles. We could pretty much cite them off. I don't know how it works within your companies, but I think some of that kind of training about our values and about what we will and won't tolerate is important. I know some of the better run, less siloed companies I've advised will have a bit on the performance evaluation that does ask about compliance. Even if you're not in the compliance program, you could be, you know, the head trader or the business developer, and your boss ought to be thinking about how is this person really living our values and really ensuring that they've imbibed the compliance program and the compliance culture. One area we hadn't talked about that I just wanted to throw out there that I always found an incredibly helpful source of information was the exit interview. At that point, there's nothing to lose. The employee's out of there, and they know they're out of there. And boy, did you get some great, great material. And of course, that would only lead you to kick yourself and wonder how you didn't get that before. How this person who was so seething with rage or had all this information wasn't willing to share it. What did we do wrong where we weren't really able to tap into what probably started as a small complaint but can build? Of course, there's some outside the pale that just are people who are a little bit unhinged and are going to be angry at anything. But boy, I thought there were some quite sensible observations that led me then in the future to try to access information before it got to the point of a separation.
Simon.
20 years ago, compliance wasn't much of a thing. It was a distraction, a drag on progress and profit. Probably 10 years ago, it started to become fashionable. But today, in particular in this very challenged world, it's not just a luxury, it's not a thing that's nice to have, it's absolutely necessary. Companies that want to make a difference, that want to be sustainable, survive, and remain profitable, embrace compliance as a fundamental. And let's not make an assumption that we're all good at this. Lisa is absolutely right. Many companies really struggle with the concept of a compliance program and whistleblowing. Culturally, in some countries, it's difficult. In China, they love it. In Switzerland, it's not part of their DNA. They embrace secrecy. In Europe, it's been such a problem, they've passed laws requiring whistleblowing programs to be implemented. And in many countries around the world, there are laws preventing retaliation against individuals. But it's still a problem. But why do we encourage it? We encourage it because the people of the organization, as Lisa said, are the eyes and the ears. People who speak up about problems keep their colleagues safe. They keep the company safe. They prevent errors and they prevent criminality. And ultimately, they send a message to the market. We are a compliant company. Come do business with us. Be our partner. Invest in us. Grow with us because we are determined to do business in a different way. And if we look at the current situation with tariffs being imposed around the world, thank you, Dan, from the United States, we know that life is going to get more difficult. Earning a profit is going to be more challenging, and that may encourage individuals and companies to cut corners. We are at a very important inflection point, I believe, in terms of compliance. Do we go the easy route or the hard route? But the most successful companies that I deal with are those that use compliance as a differentiator. We are one of the best organizations in the world, and we plan to stay that way. If there's one message coming out of the United States, it is probably that nobody will compete unfairly with the United States in the future. And so I say this, even though the United States may not currently be enforcing the FCPA against US companies, I think they'll be looking very carefully against organizations around the world who don't play fair on American soil or in American markets.
Thank you. And the last topic, so we'll cover is challenges, so to be discussed. And one topic, so I think which is worth discussing is cultural differences. Let me introduce one is for example, the whistleblowing report structure is one of the typical topics. So to discuss cultural differences. So, for example, in the US, for example, so simply speaking, so if you blow a whistle and the investigation works very well and detects some wrongdoings, you can get money. Is that effective in the US? Yes. So relatively easier to convince employees at the factory, for example, to blow a whistle. So what about in Japan? So it's totally different. So usually our mindset is much more relational, so not so independent. So, and we, as a default setting, so we should think about others around me or the factory. So for the employees working at the factory, and they live together. So almost so 365 days. So and so have lunch together, and they are close family or friends, and their mindset is their factory is their world, and so under that situation, so if the compliance folk said, please blow a whistle if you find a compliance issue, so it's not reasonable or request, and for the for the employees in the company, I think they got upset. So because that message is to instruct an employee to break the relationship, so and break that community. So and I think under that cultural situation, I think so the message to encourage speak up should be different. So and I think between US and Japan, so I think it's typical differences. But I think the UK and the US have some differences, and I'd like to ask you, so what kind of experience you face, so how to address that kind of issue.
Daisuke, can I be rude and ask you a follow-up question? Would it be okay if among the family members on the factory floor, if I see Dan doing something wrong, I shouldn't go tell the teacher, but am I allowed to tell Dan, my brother, I see you doing something wrong, or is that also considered a betrayal?
I'm told that all the time, by the way, that I'm doing something wrong.
So the typical example is that when you see the wrongdoings at the factory and say to me, for example, it looks wrongdoing, and when I said to you, so it's inevitable because the pressure from the customer is so high, and the message from the head office is unrealistic. So we need to conduct this kind of wrongdoings. So please, how can I say, give up? And then, so their response is, so based on what they did, or they ask questions other colleagues in the past, and their answer is same. It's inevitable, and it's difficult to resolve, or what we should do. So under that situation, so it's really hard to blow a whistle to the head office or compliance function.
Yeah, that is a hard one, and I'd say, culturally, you can only do what you can do within your setting, but in this in this hypothetical, if you've tried, if within your setting, it's more at least fair to give the person a chance to rectify, then at least you've done that bit. You're not a complete traitor. You've tried to resolve it among yourselves, but you can't. Then I think it is fair to then ask the person who's seen the wrongdoing to step forward and to try to raise it in a way that it can be corrected. Because I think what we're talking about are really, really risky behaviors that can damage your company, those on the shop floor as well, and your livelihood. And I think that may mean that you've got to engage in a different kind of training. We know that in the UK, I was asked probably every time I sat down in front of an audience, why don't we pay whistleblowers in this country? Or more accusatorily, you know, you Americans, you're paying people to give up information. We don't do that. We're above that. So I do think you will see cultural differences in different countries. And at the end of the day, what we're talking about is if you see something that's risky for you and your company and your however you consider your family, that you are taking steps to rectify that as best you can.
So I think since it's time, to close, so could you give us the 1 minute message to the audience each? So Dan, would you start?
Yeah, absolutely. Look, I think we've covered a lot of topics, and I'll maybe use my last minute to really highlight what I think Lisa was talking about, because I think it's an important point. The most important, one of the most important pieces of a compliance program is making sure that you are understanding these types of issues and communicating, because what you want to make sure, as Lisa was saying, that the people on the factory floor, that they change the outlook of reporting. Having financial rewards may not lead to a more effective compliance program or more effective internal whistleblowing. It's going to lead to more effective external whistleblowing. But the flip side of that is, if you are reporting internally, you're not telling on a friend and betraying a friend. You may be helping that friend, because if someone else goes to DOJ or the SEC and reports externally, that person may get prosecuted and have to go to jail. They may have to get fired, as opposed to if you report internally, you may be able to address the situation before it spirals out of control and becomes a much more serious issue. And so you are in fact helping that person, helping the company, and companies may even have some sort of leniency program depending on the type of situation.
Lisa, please.
Compliance isn't going away. It's growing. You'll see it grow in your companies. Regardless of whatever intermediary messages may be coming out of a particular set of politicians, the bottom line is the boards of the corporate world are used to looking for properly functioning companies, and that means strong, values-driven culture, including compliance behaviors that are typically shown to benefit the company. The strongest companies, the strongest performers, are not the ones paying the bribes to get the work done. They are not the ones shirking the law. They are actually the ones that have inculcated appropriate behaviors in settings that are safe for employees to voice opinions and to have the opinions and the issues that get raised get dealt with properly.
I think Lisa is absolutely right. This is not going away. It's going to get bigger and it's going to get faster. What I think we are witnessing is what I call the weaponization of compliance on the part of sophisticated companies and countries. They are not going to be defeated by those people who play badly on the playing field. We also see increasing harmonization of standards. That doesn't mean that we look at everything through a US lens. or a British lens or a Japanese lens. What we try and look for are common basic principles, and we build from that foundation. We won't always get it right. It is difficult. There are cultural and legal differences, and so what we need to do is adapt, but make sure that at our core we get things right. I always invoke a quote that I remember that Lord Woolf gave. He was the independent scrutineer for BAE Systems, who had a little issue, let us say, in the Middle East. And after he had looked at their compliance program and the pain they went through to improve everything, he said this: those at the leading edge of compliance will gain competitive advantage, in part from their high reputation. In other words, as I said earlier, compliance as a differentiator. Thank you.
Thank you. And again, so thank you very much for coming to Tokyo for this session. And we hope that this session is helpful for the audience to consider your compliance program and its effectiveness with evidence. Thank you so much.